He gave his friend $50,000, then took him to court. A handshake between old friends, a check for $50,000, and a question that would take 3 years and a courtroom to answer. Was it a loan or was it a gift? The landlord had built his rental portfolio the slow way, one duplex at a time, starting in his late 20s with a property he could barely afford. By the time this case reached the courts, he owned 11 units across the city and had a reputation among his tenants as firm but fair. He was not a wealthy man in the flashy sense, but he was careful with money, deliberate, the kind of person who remembered every dollar he'd ever lent. The doctor had been his closest friend for over 2 decades. They'd met in a community basketball league, bonded over bad calls and worse coffee, and stayed in each other's lives through marriages, funerals, and everything in between. When the doctor's private practice hit a severe cash flow crisis, a billing software migration gone catastrophically wrong had frozen insurance reimbursements for nearly 4 months. He turned to the one person he trusted most. On March 14th, the landlord wrote a personal check for $50,000. No lawyer, no promissory note, no repayment schedule. Just 2 old friends, a kitchen table, and a handshake. Then the friendship quietly collapsed. Texts went unanswered, dinners were canceled, and the money never came back. In court, the landlord's case was straightforward and delivered with the controlled anger of someone who had rehearsed his hurt for years. He testified that the doctor had come to him in desperation, had used the word loan explicitly, and had promised to repay the full amount within 18 months once his practice recovered. The landlord produced his bank records showing the withdrawal. He produced text messages where the doctor thanked him, genuinely, warmly, for saving the practice. He argued that $50,000 was not a sum a person gives away, that no one writes a check that size without expecting it back. His attorney filed suit for the original $50,000 plus $6,200 in accrued interest and $4,500 in legal fees, a total claim of $60,700. The gallery watched him testify and largely believed him. The doctor's version of events was quieter and in some ways more painful to hear. He did not deny receiving the money. He did not deny the friendship. What he denied, firmly and with visible emotion, was that the word loan had ever been used between them. He testified that the landlord had sat across from him at that kitchen table and said, and he claimed to remember it clearly, "I don't want it back. This is what family does." The doctor said he had tried to discuss repayment twice in the following year, and that the landlord had waved him off both times. He said the falling out had nothing to do with money at all, but with a separate personal dispute, a falling out with the landlord's adult son, that had made the landlord reframe a gift as a debt. His attorney argued that without a written agreement, without a repayment schedule, without any documented terms, the transfer met every legal definition of a gift. That the burden of proof for an oral loan agreement required more than a wounded memory. The gallery was no longer sure what to believe. Then the doctor's attorney introduced Exhibit 7. It was a voicemail, recovered from the doctor's phone records, time-stamped 11 months after the check was written. In it, the landlord's voice was unmistakable. He was calling about something unrelated, a birthday dinner, but at the end of the message, almost as an afterthought, he said, "And hey, don't worry about the money situation, seriously, I mean it, we're good." The courtroom went very still. The landlord's attorney argued context, that "we're good" referred to the friendship, not the debt, that a casual voicemail couldn't override an oral agreement. But the damage was visible on the landlord's face before his attorney had finished the sentence. The judge ruled in favor of the defendant. She found that while the plaintiff's sincerity was not in question, the voicemail represented a credible and contemporaneous statement that contradicted the existence of an enforceable loan obligation. Without written documentation, the ambiguity could not be resolved in the plaintiff's favor. The case was dismissed. The landlord recovered nothing. The 2 men did not speak after the verdict. The doctor sent a single text message, 2 words, "I'm sorry." It was never answered. The landlord's 11 properties still stood, and he still managed them alone. He told a mutual acquaintance afterward that the money wasn't really the point. Maybe it never was, which raises the question this case leaves behind. If you hand someone you love $50,000 with nothing in writing, are you making a loan, or are you just making a wish?